So welcome everyone to TestMax. This is BarMax, the #1 bar preparation program rated in both app stores. And today we're talking about preparing for the bar exam as a foreign lawyer. So I'm going to assume that most of you here today are foreign lawyers and will be benefited from this program. We have stuff about a little bit about the content of the bar exam and then the process of taking the bar exam. And I have our presenter today is Matthias Gonzalez. Matthias, can you turn on your camera and join me here? Are you ready? Anyway, Matthias Gonzalez is a very popular tutor in our UBE program. He has familiarity with all of the bar exams, but particularly teaches the UBE, including the New York bar exam. And just a bit of housekeeping before we get started. If you have questions for Matthias about the content of today's webinar, go ahead and put those in Q&A and he will try to handle them at the appropriate pausing points in his discussion. But if you have other questions about your bar exam preparation or about BarMax in general, then you can put those in chat because I'm also an instructor here at BarMax, and I'll be in the chat answering questions, as will another staff person, Katie at BarMax, is also in chat helping us out. So you have lots of help here today. We're here for you. And one disclaimer, can we go to the disclaimer? What we're not talking about today is how to qualify to take a US bar exam. That is beyond our expertise because it really depends on the state. It depends on what educational requirements they accept and what they don't. And the absolutely best way to learn about that is to contact your jurisdiction directly. Now, some law schools have people who help you with this. That's good for them, but we are not those people. So if you're not at a US law school that's helping you with this, then contact. I put a couple websites up here for New York and California, or whatever the jurisdiction is where you want to take the exam. The one thing I will say is that New York is accepting applications from everyone who qualifies. Again, contact them about whether that's you, but it will start on April 1st. So you want all your materials ready before then because they're going to limit that to 10,000 people. So you want to get your application in early. It's very lengthy. It involves a lot of components. So make sure you get it in, that you get it all prepared so that you can get that application in early. And with that, I am not going to take any further time from Matthias. Welcome.
Thank you, Celeste. Thank you, and welcome all. Good evening from New York. So today we're going to be discussing what it's going to be like for you to take the bar exam as a foreign applicant. So the idea behind this presentation is that you'll see some of the areas that you'll need to focus on. A lot of it will show you how BarMax will help you work towards it and through it. But really, this is generally applicable information that we've through many meetings and sessions have determined that is the most important for foreign bar takers to know. So that being said, we're going to basically cover two main sections. The first one is going to be content, and then we're also going to be doing process. So when we're talking about content, we're actually talking about some of the black letter law, right? The black letter law that is going to be different for applicants that come from other countries. Now, some of you are coming, I would assume the majority of you are already practicing attorneys in another country or licensed or whatever it may be. Some of you, probably a lot of you, are coming from civil law countries, and then some might have some common law backgrounds. So we're going to try and speak to the things that you need to look out for that are uniquely American in the sense of the jurisprudence. And then after that, we're going to talk about briefly how you can tackle each section. Because the bar exam is divided into 3 main sections. There's a performance test, there's essays, and then there's more multiple choice questions than I care to remember about, but we're gonna walk you through how you should approach each one. So that being said, as far as content goes, a few notes. The American jurisprudence system does common law. So for those of you that are coming from common law countries, will recognize a lot of the law around real property, contracts, torts, and some criminal law, but not the procedural part. And then what's going to be new for all of you is going to be the U.S. Constitution, the Federal Rules of Civil Procedure, and the Rules of Evidence. So regarding the main things that will be different for you all, which is constitutional law, and as an extension of that will be criminal procedure, which is based on the U.S. Constitution, and also the takings clause in real property, which is basically when the government can come and take your property. Before we jump into that, here is what some of our foreign students have said about us. So that you know that we are not going into uncharted waters on this subject. So I'll leave that up for all of you to read for a quick second. And also we'll be doing a Q&A at the end, so feel free to drop your questions in the chat and hopefully we'll get through as many of them as we can. Okay, so let's talk about the US Constitution. So the US Constitution is really unique in and of itself in the way that it was carved out. The way that this worked was in the 1700s, obviously the United States started out as British colonies and eventually decided that they were going to revolt against the King of England, right? So after they won the Revolutionary War, they had to sit down and try to form a government. And they ran into a lot of differences of ideas. Essentially, it was a bunch of old white men that literally locked themselves into I'd say, 600 square foot room in Philadelphia and decided that they were going to hash out a constitution. Now, what happened was that you had the different colonies, which would become the states, were demographically and geographically very different. So they couldn't come to an agreement about what they wanted to do. What they did all agree on is that they didn't want a king. They didn't want centralized power, right? This was coming from years of dealing with England, taxing the colonies and not giving them representation, et cetera, et cetera. So as these men locked themselves into a room in the middle of the hot summer, they came out with, in the US Constitution, they made 3 co-equal branches of government, and which is called the doctrine of separation of powers. And then they also developed some doctrines around federalism, which was what weight would be given to the powers that the colonies, which would then become the individual states, would have versus the power that the federal government was going to have. And again, there was a lot of push and pull around, well, we don't want to have another king, right? Some of the drafters of the Constitution even opposed the idea of a president altogether. They wanted to adhere to the rules of self-governance. And we mentioned this because on the bar exam, this is going to come up. The constitutional law is tested, right? And when it's tested, you're going to need to know the difference in the separations of powers, right? So you have Congress, which is the legislative branch. We have the executive, which is the head of is the president. And then you have the judiciary. And then you have what's called federalism, which is power that is left to the individual states for the purposes of governing that the federal government at the inception of our country did not have and still does not have. That's why for all of you that follow US news, you repeatedly see things where a president, irrespective of what political party he believes to, gets taken to court by some state or some person somewhere, and whatever law he tried to put into place gets stopped. So that's all because of the doctrine of separations of power. Then you have the doctrine of federalism. So in the doctrine of federalism, at the Constitutional Convention, the colonies wanted to make sure that they retained a certain level of self-governance, if you will, right? Because again, we don't want to have another king that comes dressed not as a king, but as a president. And the way that you will see some of this come up in the bar exam will be in the 10th and 11th Amendment, right? You'll see that some of the powers are left to the states. But at the same time, a lot of what the constitutional law that will be tested is around what powers does the federal government explicitly have. And so you'll see a lot of questions on the Commerce Clause, which is Congress's ability to regulate interstate commerce, is an enumerated power left to the federal government, meaning that the states cannot make protectionist rules to protect their own state, but to the detriment of another state. This all comes back to the idea that we're trying to be the United States. And this, as I said, will affect everything that you look at in the constitutional law portion, right? And it will also go into, okay, so let me back up. I went over the separation of powers. Here we go. Okay. This will also come into play when you see questions about whether the issue is a state court issue or a federal court issue. And these questions, whether it be an essay or a multiple choice, is going to ask you to decipher which is the court that has the proper jurisdiction, or it'll even ask you what court can adjudicate the cases, or it'll even ask you what the ruling should be, how the court should hold. And a lot of times, whether the court can hold one way or another will come down to the jurisdiction and the independent judiciary. So that brings us, in this slide, you'll see you have a federal court system, and then parallel to that, you have a state court system, okay? And they kind of mirror each other. You have trial level courts, you have courts of appellate jurisdiction, which means that they will review the decisions made at the trial court level. So and then you have the highest court of appeals of a state, or in the federal system, the Supreme Court of the United States. So in the federal court system, this is called the United States District Courts. Then you have the Circuit Court of Appeals, which basically have jurisdiction over several regions of the United States, which usually encompass several states. And then you have the Supreme Court. And then in the state courts, you have essentially the same thing. So they're modeled the same, but they both maintain their own jurisdiction over some areas of law. So for example, if it's a state law issue, unless it could be a constitutional issue, generally that's left to the state. And that goes back to both separation of powers and federalism. It's this notion that United States law leaves a lot to the states to decide by themselves, except for things that are enumerated in the Constitution or have been interpreted by the United States Supreme Court to be part of the enumerated powers left to the federal government. Okay, so this also brings up another area of law, which is tested both in the MBEs and in the essays, as is constitutional law, which is criminal procedure. Criminal procedure essentially is constitutional law. It's part of the amendments. It's the 4th, 5th, and 6th Amendment of the US Constitution. And the way that they test this is essentially they want you to know what these amendments say and how it applies to live fire scenarios. So you'll get a bunch of questions about criminal suspects and what their rights are and there aren't. So going back to this notion about when the Constitution was ratified, even though arguably the Constitution really did give a lot of divided powers under federalism and separation of powers, a lot of the founding fathers believed that still gave government too much power. So they ratified what's called the Bill of Rights, and then some. And what you'll see in the Bill of Rights are the first 10 amendments. So anytime you see First Amendment, Second Amendment is not tested usually. I've never heard of a Third Amendment question, but the 4th, 5th, and 6th is regularly tested in criminal procedure. And in criminal procedure, what you'll see is that the 4th, 5th, and 6th Amendment limit the power of government, right? So in criminal scenarios. So the Fourth Amendment essentially says that there shall be no warrantless search or seizure, which again, this was after the Revolutionary War, where there was essentially quartering, and the government, aka the British, could come into your house, could seize your things. You didn't have a right against self-incrimination. There was really no due process. People were being executed. And so to prevent this, they wrote in these amendments, which are there to protect criminal defendants or criminal suspects. So the Fourth Amendment prevents warrantless searches and seizures, which again, this was what the Founding Fathers did at its inception. As you all study for the bar, you're going to realize that apparently America changed their view a little bit on the Fourth Amendment, because you'll see that there's about 600 exceptions to the Fourth Amendment warrantless warrant requirement. But it is what it is. So, but you will see that, again, this all forms from this very uniquely American thing where we are going to curtail the power of government, and then we're going to make a bunch of exceptions where the government can actually do this. And that's the way that the bar exam will test this subject. On the Fifth Amendment, you're going to get a lot of questions. So the Fifth Amendment protects the right against self-incrimination. And typically this was only when it meant you couldn't testify against yourself. You couldn't be compelled to testify against yourself in a criminal proceeding. 200 years after this amendment was ratified in the 1960s, Justice Earl Warren decided that, well, policing has changed. It's not just testifying against yourself in a trial. And so we got the ruling of Miranda. And Miranda essentially says that you are allowed to not incriminate yourself when you are subject to custodial interrogation. That's something that once you all review criminal procedure, you will go through over and over again. And essentially, it's an extension of the right against self-incrimination, not only to when you're being asked to take the stand against yourself in a criminal trial, but also when you are in police custody and being asked questions by the police. So again, these amendments are there to limit the power of government, right? This uniquely American thing where we don't trust the government, we don't believe in the government, we believe in self-governance, and you're going to get a bunch of questions on this stuff. And generally, criminal procedure is one of those things that once you get it, you got it, and that's what it is, and then you can move on to other things. But it's very important to understand these principles, right? The reason why these things got written into the Constitution is that we believe that the government should not have this power, or well, I say we, the Founding Fathers didn't, believe that the government should have this power over people. And then the Sixth Amendment enumerates several rights, but the most commonly tested is the right to counsel, which is you are entitled to have a lawyer. And you will see how that is tested also in the MBEs. They'll ask when the Sixth Amendment right to counsel attaches, when it doesn't, right? And you will see how this, again, is there to curtail the power of government. Now, when it comes to criminal procedure and also constitutional law, in constitutional law, you will see that, again, the First, 10th, 11th, 14th Amendment, some of the Fourth, is there to curtail the power of government, right? And the way that they determine if the government has violated a person's rights is they subject the action, the government action, to a bunch of tests. You're going to get tests based on scrutiny. You're going to get tests based on whether it was a state actor or a private actor. And this is essentially how you're going to get the questions, right? Because you will need to know the legal standards that are met depending on the interaction that the government is having with the individual, to see if the individual is protected by rights enumerated in the US Constitution, right? So for example, for the First Amendment protects many things, one of which is the freedom of speech. Under the freedom of speech, if the government tries to curtail a person's, someone, and I say person because they can be a citizen, a green card holder, or someone who's not from the US, if they're within the jurisdiction of the United States, they have a freedom of speech. And if the government decides to curtail that freedom of speech, then they have to be subjected to certain levels of scrutiny. And what depends on that is where the curtailing of the freedom of speech is happening, if it's in a public forum, in a private forum. what is being curtailed, meaning if it's content, as in they're trying to keep you from saying what you're saying, or they're just trying to keep you from talking generally, right? And all of those things will lead you to different tests. And if you determine in your analysis that the government has passed the test, the level of scrutiny, then the action will be constitutional. And if the action is constitutional, then that's the answer you got to pick, right? Because that's really all this matters for, unless you're going to wind up being a constitutional lawyer, which I encourage every single one of you that want to be one to be one. It's really about how useful is this for you on the exam. And the same thing goes for criminal procedure. They'll give you a scenario where somebody's belongings were searched or a person was seized, and they will try and determine if there was a Fourth Amendment violation or not, meaning did the police need a warrant to do the search that they did? And you'll see all the exceptions to the warrant requirement. And then the same thing will happen with the Fifth Amendment, where somebody was interrogated by the police, but maybe they were in custody, maybe they weren't. And so by deciding on this, you will determine if there was a constitutional violation or not, which is what's going to help you, or essentially will help you answer the questions that are prompted to you. And both of these, I want to reiterate, criminal procedure and constitutional law can come up in an essay, which we'll discuss later what essays look like. And it can also come up and will come up in multiple choice questions. So it's important to understand both the nuances of the exceptions and also how to lay out all of the doctrine in a bit more detail than you otherwise would need to know for a multiple choice question. Okay, so now that we've discussed the content, right? These are the things that are uniquely American in the way that they are administered. As we discussed, we have constitutional law, and then we have criminal procedure, and then you see this come up also in property as well sometimes. There's also a process, right? The bar exam is very, very unique. Depending on what jurisdiction it is that you're taking it in, whether it's the uniform bar exam or the California exam, then you have three different sections. But generally, both the California exam and the UBE offer multiple choice. And in writing, there's a performance test, which we're going to get into in a second about what it is and what it isn't. And there's also essays. And the essays, as I said, that's about your knowledge of law and being able to lay it out, meaning explain the rules that are being tested, analyze them, and then conclude on them. So the first part is usually the performance test. Now, in UBE jurisdictions, the uniform bar exam, it's 40% of the written score and 20% of the overall score. My students repeatedly neglect this until 2 weeks before the exam under the guise of, well, it's all there because they give you the law, and then that's a not good approach, right? Generally, what you want to do is you want to give these MPTs the proper time so that you learn how to do them. And we'll discuss briefly how you should approach these. And then in California, in the UBE is 2 tasks. So you get 2 of these scenarios. And then in California, it's 1 task, which is approximately 28% of the written score and 14% of the overall score. And this is tested everywhere except in Puerto Rico, and yes, including the District of Columbia, meaning Washington, D.C. Okay, so now for the purposes of the uniform bar exam, it's 2 tasks in 3 hours, right? So when I say task, I mean literally they hand you a book. And it's almost like you're in a law firm, except it's not, as we'll discuss. And you are asked to do something. You're asked to write a memo. You're asked to write a brief. You're asked to do lawyerly work. In California, it's 1 task and it's 90 minutes. If any of you want to see this in more detail, you can check out the performance tests webinar. It's called Performance Test, What Graders Want webinar. What Graders Want. It's the webinar and as well as our other BarMax videos. So, okay. All right. So what are some of the issues that are faced by, well, really by all examinees, but certainly by foreign examinees? It's timing, timing, timing. I cannot stress this enough. Anyone, well, maybe not anyone, but most competent people can write a good performance test in an unlimited time, because you're essentially given the whole universe in which you will be operating. However, you're not given that, right? On the UBE, you got 3 hours to do 2 of them, or you have 90 minutes in California to do 1, right? And I believe the biggest thing that will trip up foreign lawyers is that a lot of you are already practicing. So you're used to being handed tasks like these, and you're used to doing them well. The problem is that you're used to doing them at most in a whole workday or in half a workday. Either way, it's a longer period of time than what is allocated in the bar exam. In the bar exam, you have an hour and a half to read the assignment. You have an hour and a half to read, to read the assignment, to look at your library, which is your law, the law that is being presented to you. They give it to you, whether it be statutes, cases, treatises, etc. Then you have your facts in the case that you have to analyze. You have to review those as well. And you have to draft what it is that is being asked of you to draft in an hour and a half. So whether it be the memo, persuasive brief, or whatever it is that is being asked of you, everything has to happen in an hour and a half. So when I say that, they call this the performance test, right? Because they want to see how good a lawyer you're going to be. I can't imagine, even at the most stringent law firm, you will be asked to produce a document within an hour and a half that will actually be used in any legal context, right? It would probably border on malpractice. But for the purposes of the bar exam, they do want that. So they'll call it a simulation, but you need to not treat it like a simulation. You need to actually review things at a much faster pace, and I would say in less detail than you would in your work environment. Okay. Another thing will also be, I'm sure that every single one of you speaks great English and can carry on a great conversation and so on and so forth. However, writing tends to be different. English is not my first language. There's times where I spell things phonetically in Spanish and I get them wrong, and I grew up in the States. And so this will happen. My advice to you all is to streamline the language issue, which is essentially go forth as directly as you can. Don't be eloquent, and we'll get to that in a second. Going back to the PT, the performance test being a condensed version, right? So as I said, this inter-office memo has to happen in an hour and a half. So you're not aiming for perfection, right? I mean, you obviously want to put something out there that is readable because you're going to be graded on it, but you're not aiming for perfection. In the performance test, they do ask you to follow memo format. So they do want you to follow what would otherwise be the presentation of a formal document, but it is not to the level of perfection. And actually, if you start spending time on that, first of all, there's no points allocated to formatting perfection. And second of all, you are taking away time from actually getting information on the paper or on the computer that will get you the points to pass. So again, you want to do the memo or persuasive brief or whatever it is that is given to you after reviewing the library and the assignment in a topical way. So what I mean by that is if you are given 3 things that you're asked to analyze, then you need to find the law and you need to find how it applies to your facts, and you need to deliver that on the paper. You do not need to write a theoretical paper, going into each and every single one of the areas or interpretation of the law that you've been given. If you do that, you will run out of time. On the UBE, you will run out of time into your second performance test because you'll spend more than an hour and a half on the first one. This is assuming that the jurisdiction which you take it in does both of the performance tests in 3 hours. Now with the pandemic, they're breaking up a lot of these. Depending on the jurisdiction, they're doing an hour and a half, so they actually stop you after the first performance test, and then you begin the second one. They stop you before, the second performance test. So I say this to basically tell you, tear down everything that you know, okay? You are not trying to write a perfect performance test here. You're not trying to write a perfect memo. That is not what they're looking for to give you points. They're looking to see that you are analyzing, understanding what is being assigned to you, and that you are delivering it in a written document within an hour and a half, right? They're testing comprehension, and they're testing a little bit of uniformity because they do allocate some points to format. They are not testing how good a lawyer you are, even though that's what they call the performance test. That's what they portray the performance test to be. All of you are already amazing lawyers or will be amazing lawyers. The performance test is not the time to show that. The performance test is the time to get it done, get in and get out and move on to the next things, right? Because it is at the end of the day 20% of the bar, and we do want to do well on it, but we don't want it to be the reason why we already start the bar exam behind, nor do we need to pay that much attention to it because it's only 20%. Okay, so as I was touching on earlier about dealing with potential language barriers. So when it comes to language barriers, you want to write directly. When I say writing directly, I mean, try to think about how your parent, probably your mother, spoke to you after she told you things 5 or 6 times, right? It doesn't matter what culture you come from, moms are pretty consistent throughout the world. When they're telling you something for the 5th time, they're telling you in few words and in a very direct statement, because what's coming after that is not fun, right? So you want to channel your inner parent to some extent. For some of you, it might be your father or other significant parental unit, but that's who you want to channel when you're writing. You want to say what you have to say. Obviously, you can take the animosity off, but you need to just say what it is you need to say directly. So that means don't write in past or future tense, right? English is a weird language. We conjugate verbs in a very different way than a lot of other languages. So don't try to speak in past tense or in future tense or anything but directly. Act like you are speaking to that child that is apparently not understanding what you're trying to tell them, right? Eloquence is not your friend. Eloquence meaning showing how good you are at speaking English, even though it's not your first language, which I'm sure all of you speak and write it wonderfully, is not going to help you on the performance test, right? Just say what you need to say. As long as you are conjugating verbs properly and you are speaking in complete sentences, you will be fine, right? You don't need to be Shakespeare for this. I can't emphasize that enough. I would like to think that I can write really good motions in my work and I do good legal writing. When I took the bar exam and I did the MPT or the performance test, I did not care. I just said what I had to say. I got as much of it and all of it on the paper within an hour and a half, and then I moved on. And now, after I passed the bar, I take my dandy time on all the motions and legal briefs that I write because I take a lot of pride in my eloquence. But again, in the bar exam, that is not what you want to do. So make sure that, again, you're tearing down what you know, because there's no points allocated for that. So the way you want to approach this is if there's no points given to it, then I'm not giving it any attention, right? So that brings me to making your points. I feel like, speaking in other language, we tend to be a bit more wordy. This brings me back to speaking directly. Say what you have to say. You don't need to preface statements or paragraphs with 2-3 sentences given context. Do a half sentence of context and then get on to the things that are going to give you points on these on the performance test. Okay, so after you do the performance test, then you have the essay portion. So the 2 subjects that we discussed earlier, as I said, they're tested both in the essay portion, and they can be tested rather in the essay portion. They alternate what they test. So some years they'll come up, some years they won't. And it's tested on the MBE. For the purposes of the UBE, you get 6 essays, which is 60% of your written score and 30% of your overall score. Even though it's only 30%, this tends to be what kind of makes or breaks a lot of test takers, both foreign and domestic. So you want to make sure that you have your game plan going into essays. I have unfortunately seen a good amount of very bright, good, legally knowledgeable people with great writing skills that did not perform well on the essay portion because they were not, again, giving them what it is that they wanted for the purposes of obtaining points. In California, it's 5 essays and you get 1 hour for each. They actually want a bit more detail, actually quite a bit more. And in that case, it's 71% of the written score and 35% of the overall score. So there's 7 subjects that are tested in multiple choice, plus there is other subjects which are tested in the essay portion. Okay, so you get 30 minutes for each, and it could be on any of the subjects that you all see there. So the big 7, which is civil procedure, constitutional law, contracts, crimes, evidence, real property, torts, and those are the ones that are also tested in the MBE, which can be tested in the essays as well. Plus, you're responsible for knowing everything you see there on the right column, which is agency and partnership, corporations, family law, secure transactions, trusts, wills, and conflicts of law, which is like usually a crossover. Now, obviously, there's only 6 essays, so they can't test all of these things. They tend to take turns in each administration of the test in choosing what topics they will test. We don't know which ones they'll test. So, and no one does. Even if they purport to, based on 20 years of analyzing, it's at best an educated guess. So you need to make sure that you that you know that you have enough knowledge to write about and discuss all of these subjects. Now, obviously, the big 7, you're learning anyway because you have to do MBE questions on them, multiple choice questions. But the other ones, you have to learn only for the purpose of they might appear on the bar exam. Yes, I agree with any of you that might be thinking that that might be too much, but it is the system that we operate in. So some of the states that don't administer the uniform bar exam will substitute some of what you see there with state-specific material, which we won't get into today. So what you can do is you can look up, if you're planning on taking it in a state that is not a uniform bar exam state, what the law examiner, the bar examiners there have determined is fair game to be tested. So in the California bar, it's the 7 MBE subjects plus professional responsibility, community property, wills, trusts, agency and partnerships, and corporations. So those are, again, you might get them, you might not. They're the wild cards, if you will, of the, well, they're all wild cards, but at least the big 7 you're going to see in the multiple choice. Okay, so challenges that foreign lawyers will face in doing the essays. A lot of countries still test this level of knowledge orally, where you're asked to recite the things that the areas of law and analysis that you have to do. That doesn't happen here, right? Other countries require very extensive writing. Again, California requires a bit more extensive, but for the purposes of the uniform bar exam, they're only giving you a half hour to write this, read and write it, right? So you're probably not writing at most more than 20 minutes. So there's only so much that you can say in 20 minutes, right? So usually in the UBE essays, you might get about 3 to 5 issues, right? So you get presented a scenario, you get it's almost always a whole page of a factual hypothetical. And then at the end, they tell you that somebody brought a motion to dismiss, that somebody, wants to exclude evidence or wants to do this or do that, or they tell you how should the court rule. Either way, which is not fun because it requires a bit more of understanding exactly what it is that is happening in the fact pattern. But in this fact pattern, issues will be triggered. And generally, they are 3 to 5 issues, right? And usually it's cohesive. They tend to test one area of law, right? But they have over time gone more towards testing hybrid essays. So that means that the question might have it might be a contracts question, but it might be that the litigants are in different states. And so it might throw in there a jurisdictional issue, which is civil procedure, or they might throw in there a conflict of law issue. I believe when I took the bar exam, we got a constitutional law and civil procedure hybrid, right? So they're asking you things about, well, how should the court rule on this from a standpoint of do they even have jurisdiction to do this? And also there was a question in there about, is this even constitutional? So they have shown a propensity to move a little bit more towards those things. In California, you get about 6 to 10 issues for each essay, but you have an hour to write them. So it's essentially similar, but just more extensive. And so therefore they require a bit more detail. But overall, I would say comparatively speaking, this is a much more concise format that they require of you in the written portion of, or typed portion of the bar exam. And lastly, it's going to be very important that you follow IRAC format. Okay, so what is IRAC? IRAC stands for Issue, Rule, Application, Conclusion. So the first thing that you need to do is you need to identify the issue or the legal principle that is I hate to use the same word, at issue in the fact pattern, right? So what is the problem, right? What is the, why did they give you this? Somebody needs legal advice, right? And so that's what, and you're being asked to analyze that, right? And so that's the issue. You need to identify what the issue is. What happens to every examinee until they practice and practice and get better is that they'll do one of two things. They'll either, or three things, they'll spot issues that aren't there. So they'll essentially create a controversy where there's not one. They'll completely miss the issue, which means they won't even realize there was a problem, or they will over-explain an issue or misinterpret an issue that they did find it. They found it, but they interpreted the scope of the rule wrong. Maybe they were missing an element, and so they got the wrong conclusion. So that brings us to stating the applicable rule, right? So you're going to get this fact pattern. It's going to be Matthias and Celeste had a contract, and Matthias breached, so Celeste wants to sue, right? Well, that could be 100 things. It could be, is there a defense to a breach of contract? And obviously the fact pattern will give you a lot more because it's a whole page. It'll tell you exactly what's happening, but you need to be able to identify the issue and state the proper rule, right? And the rule is going to come from your outlines. If you're using BarMax, it's going to be all the things which are on the iPad, which you're able to highlight as well. Or if you're studying from, our book, it'll be in the outlines there. And that's what you'll need to deliver. You will need to explain what the black letter law on this issue is, right? That's where you're testing you're beginning to test your legal knowledge. After you've stated the rule, which is hopefully the correct rule for the sake of doing well on the essay, you need to analyze by explaining how the rule applies, which is the application portion. So you need to explain how the rule that you just stated applies to the facts of the fact pattern which you are given. So Matthias and Celeste are suing each other. Well, what is the problem that is going on there? And based on your rule, you need to take your rule, as I call it, elementize it, which means separate it into the separate elements, separate portions of the rule, and go through each of the elements and say, okay, is this element met? Is this element met or not met? And then whatever you determine, if you determine that all the elements of the rule are met, then you have a legal conclusion, which is number 4, to come to. If you determine that the elements of the rule are not met, then your conclusion should be another way. This kind of goes back to the criminal procedure and constitutional law things that I was saying. They're essentially going to tell you, in Crim Pro, somebody was arrested. Did the police need a warrant or not? You're going to take the exact rule, right, which is generally going to flow from one of the amendments, plus the exceptions, et cetera, and then you will determine based on the facts who was correct. Was the government correct? Was the suspect, were the suspect's rights violated? And so you give your conclusion and you answer the question, right? Which the question will say, should the case be dismissed? Was the government correct? Things like that. And you will do that 3 to 5 times in one of the essays. Now, this sounds like a lot, but you will spend so much time reviewing rules after rule after rule that you'll just be able to recite them off the top of your head, and you will hopefully do enough questions to understand how each rule applies, the proper scope of application for each rule, which will lead you to the right conclusion. So what the bar examiners do is they don't allocate any points for identifying the correct issue generally. What they do, or at least in the UBE jurisdictions, what they give points for is, did you state the right rule, and did you state it completely? Did you apply the rule correctly? Meaning, did you walk through the statute, as I say? Did you go through the rule to determine what the analysis was? And lastly, did you conclude correctly? And if you do so on all of those things, then you receive all the points that are allocated to that issue. And then you do it over again, and then you do it over again, and then you do it over again, and you finish that essay, and then you do it 5 more times. But that's essentially what it is. That's why learning process is just as important as learning content. Otherwise, anyone that the state bars decide is eligible to take the bar exam would be able to take it and pass if all they had to do was memorize, right? It's about testing your knowledge and your application of the rules, because although the bar exam does not really resemble how you practice law, it does go into how legal work tends to play out a bit, right? Which is, you know the law, you apply it to the facts that your client comes in with, and then you give them your legal advice, right? Except in the bar exam, you're doing it in a half hour, 3 to 5 times for 3 hours straight, or now with the pandemic, they break it up. Some jurisdictions do into an hour and a half at a time. Okay, and as far as the MBE questions is concerned, they're just multiple choice questions, 4 answer choices. We won't get into that here, but there's another webinar that speaks to that. But they're essentially asking you to do the same thing, which is analyze law and give your conclusion, except your conclusion is actually going to be in one of the 4 answer choices that are there for you. Okay, so with that, I leave you with some of what our students are saying, and I know we want to open it up for a bit of Q&A. Sorry, I muted myself. Is the New York bar available for international applicant? I am not sure. I think that was within the things that we said, unfortunately, we wouldn't be covering today. Do you know if they have indicated the options taken online? I do not know. So again, we're going to kind of speak to, content versus process issues. Unfortunately, I mean, I am admitted in New York, but this was before the pandemic, and I can't really speak to what it is that they're doing now. Okay. Do you think the remote version of the bar exam is here to stay? Oh, that's a good question. This is very convenient for foreigners not based in California. Have you heard anything about it? I personally haven't. Yeah, okay. Other than my own personal opinion, which seems to be what you're asking, I don't have. I would imagine that they should, right? Because of how convenient it makes it. However, if I had to take a guess, if at some point we ever go back to normal, which who knows what the new normal will be, I would imagine they're going to start making people sit for it again. But I don't know. I have no idea. This is usually decided, though, by judges at the highest level in each state, right? So it's not like it's a very democratic process. That's all I can tell you about it. What is black letter law? Black letter law means the law as it's actually written in the Constitution, in the rules of federal procedure, in the rules of evidence, etc. Anywhere that it is written, that is what is the black letter law, meaning, for example, the First Amendment protects the freedom of speech, right? That is the black letter law. It's almost your rule statement, if you will. That's what we mean. This comes from the saying of it got put into black ink, right? It's what's written down. I would appreciate some tips on how to pass California bar with the English as a second language experience. Okay, well, hopefully we gave you a few. I've noticed that I ran out of time during the bar exam, even though I know the answer. Well, we spoke to, for Victoria, we spoke to some of those things here, right? About being concise in your writing. If English is not your first language, write in the present tense. Keep it moving, right? You don't have to be a law guru for the purposes of the bar exam. The bar exam is a test of minimum competency. So yes, and this webinar will be available later, so feel free to revisit it. As a foreign lawyer, when preparing for the bar, I noticed that no matter how many times I read a subject and understand it, my results in the MBE portion of the exam are very poor, and this is very discouraging. Any tips would be very welcome. I would say do them open book, untimed, and the way that I would tell you to do this would be go through, read the question, right? The call of the question and the fact pattern. Think about what rule is triggered, and then stop before you ever look at the answer choices. Go into your outline, open the outline to the rule that you think is the one that applies to that question and fact pattern. Read through the rule. Ask yourself, is that the whole rule that I was thinking about? Or is that the rule? Was it most of it? Did I miss an exception? Was I not remembering the whole thing? And then you take it as it is, right? So you read it, kind of understand what's going on in the rules, and then you go back to the fact pattern and you run the rule through the fact pattern. So you apply it to the facts, and without ever looking at the answer choices, I encourage you all to use a flashcard if you're doing it on paper to cover the answer choices. You are going to apply the rule that you found and that you think is correct to the to the fact pattern in the question, and you're going to determine what the answer to the question is, right? So the answer is usually going to be is going to be yes because or no because, right? So you want to know, okay, the answer here is going to be yes because, and it's this part of the rule, or no because, and it's this part of the rule is not triggered, right? And then after you already know what the answer is, you take the flashcard off, or you do whatever it is, you look at the answer choices, and you look for an answer choice which reflects your reasoning. If you still get the question wrong, you stop and you ask yourself, what did I do wrong here, right? What went wrong? Did I not understand the scope of the rule? Did I just not understand the rule? Did I not understand the applicability of the rule? And what I always tell my students is then go back and annotate your outline to reflect what it is that you got wrong in that question, so that you're constantly dialing in, right? You're constantly adjusting the rule to make it work for you, because the rule is only as good as it's going to help you get a question right on the bar. Okay, so I would appreciate some tips on how to pass English second language notice. Okay, yeah, that's I think a repeat. Louisa, yes, please give us tips to pass bar exam for ESL students. Okay, so I believe that I touched on a few of those. You know, the general principles that we've noticed about English as a second language students. Again, English is not my first language. So I fully empathize with all of you. And yeah, again, you know, make sure you're concise, speak in present tense. You don't have to show them your best English. You just have to, it just has to make sense so they can give you points. Do you recommend to state in the beginning of the paper that taking the bar exam as a foreign attorney, please consider English as my second language. Should we let examiners know that? Merv, I think that's one of those things that goes without saying. I think that even people who American or native English speakers that don't test as well on the bar still at least, lay their ideas out okay because they speak the language. So I don't think it's necessary. I'll give it to you this way. I wouldn't say anything about it. Also, I've only met one bar grader. They're kind of like unicorns. You've heard about them, but you've never seen one. And she didn't seem like a very animated or empathetic person generally. So I don't know to what extent that'll help. I think that if you want to pass the bar exam, you have to learn the law and learn how to take the bar exam. Not how to practice law, not how to do anything else. Just learn what it is that they want from you. I tell all my students the same thing. I say, this is seeing behind the curtain. For any of you that have seen the very old movie, The Wizard of Oz, at the very end of the movie, he says, pay no attention to the man behind the curtain, right? Or something, I'm paraphrasing. Well, once you see behind the curtain, you can't unsee it. Remember, once in the movie, once they saw behind the curtain, there was no wizard anymore, right? For me, that's the way I felt when I was taking my bar exam, and certainly thereafter when I've tutored, is that once I saw behind the curtain, and by that I mean I understood what they wanted from me. On the MBEs, I understood how they were almost always testing exceptions to the rule, or they were trying to make you fall into an emotional trap. Right, where they give you really bad, egregious facts, somebody that you just want to, throw in jail for the rest of their lives, and then it turns out that the law protects them, right, in some way. Or on the essays, understanding that, I'm just going to give them what they want. Here's your issue, here's your rule, here's your application, here's your conclusion, goodbye. I hope I never see you all again, right? On the performance test, yes, I, knock on wood, have never lost a motion, have won every motion to dismiss, and I will write to where the judge doesn't even want to keep reading. The judge just says, counselor, please tell me what this is about, right? But I get to do that in practice. On the performance test, I gave them what they wanted in an hour and a half, and I moved on. And I finished both of them. The majority of my friends, the ones that passed and the ones that did not finish the MPTs. And that essentially put them in a position where they were trying to play catch up already after the first session. So that's why it's very important to understand what it is that they want from you on the performance test, like I said, which is concise and good delivery versus, this extensive legal analysis or argument, depending on what kind of scenario you get. So that was a bit long-winded, but Merv, I hope that answers your question. Okay, Kiama, Matthias, do you provide tutorial services for California takers? Unfortunately, I'm licensed in UBE jurisdictions in New York, not in California. We have excellent California tutors. Can you recommend a tutor? Yeah, okay, I see Celeste is answering. See, Celeste is the wizard behind the curtain today. Celeste is going to answer this question live. Okay, all right, let's see. I just lost my place here. How to download this handout. Okay, so I guess it says Celeste is going to answer this question live. I'm guessing that's coming up at the end. Just a nitpick question. Can we also?
I'm sorry, I clicked that button by mistake.
Oh, you did? Okay.
Some wizard behind the curtain, huh? Anyway, the handout will not be available, but the video itself will be viewable within BarMax and on the TestMax YouTube page. Keep answering these questions, Matthias. Bye.
I'm here for them. I love doing this. Technology is not my thing, as you all figured out. You're lucky I can get on Facebook. Let's see. John Michael Vita, nitpick question. Can we use crack instead of CRAC, conclusion, rule application, and then conclusion for the New York bar? That you can do it. Okay, so my students ask me this question all the time. They say, Matthias, is this a stylistic choice, IRAC, or is this or is this was actually needed? Here's what I will say to you about it, John. That let's say you do crack versus CRAC instead of IRAC. Let's say that you have the right rule and the analysis is good, but your conclusion is wrong. I know for a fact that I concluded incorrectly on at least 2 of the essay, not questions, but issues, and still wind up scoring right what you can score, which goes to show you can get things wrong and still do well. But if your conclusion is wrong, but everything else is right, you'll pick up points for the right rule and a good analysis. You're going to lose points in some of the analysis and the conclusion, right? So if you're doing the CRAC, right, you're already letting the bar grader know, hey, I got this wrong, right? Versus you're developing an IRAC, you're developing a good issue statement, you're giving a good rule, good analysis, and then towards the latter part, you're like, oh, but he got the conclusion wrong, right? So remember, these bar examiners have like 3 minutes to grade each essay. I don't want to, have any preconceived notions of anyone, but I don't remember being 10, 11 years old for career day, anybody standing up, even the people that stood up and said, I want to be a lawyer, saying, I want to be a bar grader, right? These people are probably doing it because it pays the bills and maybe they're in academia and they want some insight, right? So they're not going to spend an awful lot of time. So give them what they want. Right? I'm all about give them what they want, so they give you the points. You are in a transactional relationship with the bar grader. You just need to give them what they want, and they need to give you the points, and that is it. Fernando, MBE 50%. How much time for MBE? I don't know what you mean by MBE 50%, if that's where you're testing or if that's what they want, but that's not what jurisdictions generally want. You generally need to score higher depending on where you are. Usually in the mid 60s is where you want to fall. How much time for the MBE? So it's 200 questions in 6 hours, which is before the pandemic was broken up into 2-3 hour segments with lunch in between. 100 questions each 3 hours. Since the pandemic, they've started doing 50 questions, an hour and a half hour break, and another hour and a half with another 50 questions. You go to lunch for about an hour and a half, depending on the jurisdiction you're in. You come back in the afternoon and you do again 50 questions in an hour and a half, and then half hour break, and then 50 questions for the next 50, an hour and a half for the next 50 questions. And my understanding is that you can't go back once you've completed those 50. So that's what I can tell you about timing for MBE. It comes out to about 1 minute and 40 something seconds for each MBE question. So anyway, look up your jurisdiction though, right? If you're taking it in New York, check, because it's a moving target. But yeah, what was the format of the remote exam in February? Well, again, this depends on the jurisdiction. Different UBE jurisdictions did it differently. I had a student in Missouri who basically took the exam like there was no pandemic, I guess, except, they wore masks and were socially distanced. But other than that, that's the format they did. New York did an hour and a half for, so the two MPTs, the 2 tasks, which is usually 3 hours for the 2 tasks, they divided it up to an hour and a half each with a half hour break in between. Then you come back in the afternoon in the first day and you have the 6 essays. And in February, they did 3 essays in an hour and a half. You took a half hour break. And in after the half hour break, you came back and you did another 3 another 3 essays. And then for the MBEs, it's what I just said about 50 questions, hour and a half hour break, 50 questions, lunch, 50 questions, half-hour break, another 50 questions, and you're done. A total of 200 multiple choice questions. Evelyn, there's some rules in the outline that take more than 1 sentence. How can one condense into 1 sentence writing an essay? So I apologize if what I said, if I misspoke or if it didn't make sense. Not every rule will be 1 sentence, but you still want to strive to be as concise as possible, right? So a lot of that is creating your own study materials, right? So if you take this big rule, right, like parole evidence, for example, take the elements that are important in it and make it into your own rule statement that still has all of the black letter law, right? But that is not as wordy. That's what I mean about being concise. Now, listen, there's not a, you can only be so concise, but if you compress it enough, it becomes less things to remember and less things to type back out, which you will still receive full points for. Okay, is the remote New York exam different from the traditional exam? So it's different in the process, which I just discussed in detail a few times. Should you study differently? I think the only thing you should do differently, if anything, I personally wouldn't do anything differently. But if you want to do something differently, it would be maybe when you do your practice exams for your MBEs, do them 50 questions, an hour and a half. So do it in test conditions, right? And however it is that they're going to test your administration of the bar exam, which is a bit of a moving target, but at least the last 2, October and February, has been an hour and a half, 50 questions, half an hour. So practice the way you're going to test is my short answer for that. Let's see. Okay, I think maybe Celeste answered that question. I don't know, it disappeared. Okay, how much time for the MBE? We already did that one. What is the law other than the black letter law? There's not, but there's interpretations of the law, right? So the scope of the rule. But yeah, black letter law means what's actually written in the rule book, constitution, whatever it be. Okay, hold on. I want to make sure I didn't skip any bodies. Okay, what was the format? I answered that. There's some rules and now, yeah, okay, condense. How many parts? What is the law other than the black letter law? Okay. Anna, for the performance test, I found that certain cases were hard to understand, which I consider a comprehension problem. Having to process the cases and know the facts are challenging. Any suggestions to address that? Would the solution be to read the cases and make myself familiar? So, so again, in the performance test, you get the task memo, then you have your facts section, then your library, and then you have to write. The task memo tells you what it is that you need to do. I would advise you to go from the task memo to the library, right? Because you know what you need to do from the task memo, and then in the library, you know what now you know what the law is around what it is that you need to answer, and then after that, you read the facts, and the facts tell you what it is that you need to do, or rather, give you everything to put it together and draft it. My suggestion, other than that, now obviously we can go and we do go into a lot of detail with this with the students, but the gist of it, if I had to give you my one-liner on this, would be compartmentalize your time. So yes, doing everything in 45 minutes is challenging. So get used to doing the task memo, reading it in 3 minutes. Get used to Get used to doing the library in 10 to 15 minutes, somewhere between that. Get used to reading the facts in about 15 minutes or so, and then you outline before you start writing. So compartmentalize your time. Instead of saying I have to do these three things: read the task memo, read the library, read the what do you call it? The facts section. In 45 minutes, say, okay, I have 15 minutes for this, 15 minutes for that, 10 minutes for this. Also, outlining what you're about to write typically is a bit more tedious in the first 45 minutes, but then makes the next 45 easy or easier. There's nothing easy on the bar. We just need to write the rule, or we need to cite it. You don't need to cite rules. Citation is not required. I mean, like, you can say something like, under the rules of federal civil procedure, a court has personal jurisdiction when a person is domiciled in the state where in the forum state where the district court is located, right? But you don't need to say under rule, I don't even know what rule number that is, but yeah, so to your point, you don't need to cite it, right? Because I clearly don't know. Now, in your performance tests, when you're taking your rule and putting into what you're analyzing it, there you need to cite the case that is given to you in the library section. There you do need to cite it. So that's a small distinction there for Louisa. Mohammed, I'm sorry, I got confused. Is the bar exam for foreigners different from those who got? No, it is the same bar exam. Because I heard before that California has 1 PT and 2 essays. I think you might be talking about the baby bar. I don't know. I'm not licensed in California. I know that California offers what they call the baby bar, but I think that that's just an alternate avenue to getting your law license in California, which is available to international students as well as students that went to a law program in the United States as well. Okay, Juan Jose, do you think the BarMax calendar is suitable for foreign lawyers, or would you advise us to go through the documents at our own pace structure? Generally, I think that the BarMax calendar is a good tool to start off with. Now, what I tell my students is life doesn't happen in a vacuum, right? What I do for my students is I give them their own individual calendar, which is usually based off of what BarMax has, but tailored to their specific needs or time constraints. So I would say for Juan Jose, do that. Try to. I don't know about doing it at your own pace. I think, the test is when the test is, right? So you can't delay the test. And you got to know everything, or not know everything, but you have to study everything before the exam. So, yeah, I would say maybe touch it up a bit to your needs, but make sure that you've gotten through the material by the time you have to take the exam, right? So if that means you're working Monday through Friday, well, then guess what? Your friends are not going to see you on weekends for the next 3 months, right? This is the way it is. But yeah, so I would say tailor it a bit. I definitely do that for my students. Like I said, I give them a whole new thing, but yeah, I would say work off of that and make it work for you to where you're reaching the same the goal line, at the same time, but your own way, or start it earlier. Okay, Thomas Chambers, Matias, what balance of time split would you suggest in terms of preparing for the multiple choice test and the essays? Great question, Thomas. So I'm going to tell you this anecdotally because I think that it's specific to each person's needs. They gave us a course in law school my last semester. And I remember like the first day of the course, they had us do an essay. And I remember I got my name on there and that was it. And so I said, okay, I need to personally focus a lot of time on essays. So I probably spent about 65% of my time or 70% of my time on essays, but that is not to say everybody should do that. I did that because I felt like my essay writing needed a lot of work, and, excuse me, because I'm also a good multiple choice test taker. Like I historically have been. I used to not ever study for anything in school, but if it was multiple choice, I could figure out a way to pass it just by, you know, understanding what it was that my teacher was trying to test. So I would say if you feel like the essays will be a problem for you, then maybe you allocate a little more time. Now, I will say, my situation was a bit weird. I scored higher on the essays than I did on the MBEs because I allocated so much time to it. And the MBE score, my understanding is it's curved. So even with the curve, I still scored higher on the essays. I scored up there. And then I think 90 something percentile, but it was maybe a bit of overcompensation. So you gotta, I will say this though, equal time is not the answer, right? It is not a one size fits all endeavor with the bar exam. Where you see that the work is needed is where you allocate the work. Would you advise dedicating more time to multiple choice subjects or a complete balance of coverage essay topics too? So that's the big 7 versus the plus, right? I think inherently you have to spend more time on the big 7 because those are going to come up. If they don't come up in an essay, they're going to come up on multiple choice. And you'll see when you guys take BarMax that some of the other, you'll see the way that the time is allocated, more time is allocated towards the big 7. Why? Because they're tested more. So you have to do them. You have to spend a little more time on them. And also remember the other subjects, they might not even come up. And if any of you guys wind up being my students, you will hear this story again because I lead with it. For my bar exam, I made the mistake of saying, oh, but Will's has been tested like 3 years in a row and they only test it, once every 2 years usually. So there's no way that they're going to test it again. And I didn't take the course in law school. So to this day, if a friend of mine, if somebody wants me to write a will for them, I refer it out. I'll just forego I just had a bad experience with not wills as a subject to study now after years of teaching, but it just left a bad taste in my mouth. So I get to my bar exam. We do the performance test. The second performance test is a hypothetical about wills, which was great because they give you everything you need in the performance test. So I thought, great, they already tested it here, kinda. They're sure as heck not going to do it on the essays again. And then we come back in the afternoon. I open the essays, and the first line says, "So and so wrote a will," and so that just goes to show you that you don't know. You can hedge your bets. I did. I wound up doing fine, but I would advise you not to. Right? Like that. If that's one thing, if I could go back and get a higher score, that I would do is I would give the other subjects a bit more time. So don't neglect them, I guess is the short answer, right? But definitely the big 7 do get more time because they're tested in both sections. Matthias, what was your memorization style? From anonymous attendee. Okay. So anonymous, what I would say is for memorizing, so I did this in, okay, little backstory. They tell you take a week between graduation here in the US and starting to study for the bar, and I wasn't going to take that chance. So I started a week early, right? We graduated on a Friday, and Monday I was in there. So I went back to my school and I commandeered a room in my law school. And what I did is by the time I was done studying, that room, literally every square foot of the wall, or square meter for those of you who are in other countries that do the metric system, was covered in these huge sticky notes, right? Like literally, it looks like this, right? But it's as big as a poster, but it sticks to the wall. And I wrote things big enough, even though unfortunately, one of the many things that law school gave me was bad vision. I could see it from where I was sitting in the room. So I was in like this little spinny chair, right? And I could turn and see what rule it was. And it kept the flow going quicker. especially in the latter part of the studying. So writing big things, flashcards. I never did flashcards in my life until I started studying for the bar, but I found color-coded flashcards to work. So if I found something that was commonly tested and that was also something that two things, right? Getting it wrong all the time or most of the time and commonly tested, I put it in a red flashcard, right? So like red meant I needed to give it attention. So that's another thing I did. I also made acronyms, right? Things that would help me understand. Also, the sticky note thing or whatever, sticky posters or whatever they're called, something that helped me, but I don't know if this is individual to me, was I could, in the bar exam, take myself back to the area of the room where that poster was. And it was almost like I could see the poster and then I would just read off of it in my head, right? I don't know if that works for other people. I know people learn or memorize by listening. I have a student who I'm very confident just passed the bar exam despite a bunch of adversity that got thrown at him. He listened to tapes. He liked to listen to tapes. I could listen. That's a quick way to put me to sleep, is getting me to listen to something. So you got to kind of find your own way. What I will say is do what's been working for you. If you've memorized the majority of your life doing it one way, do that and then add to that. Don't just come in with a new idea for the purposes of bar exam. That's you don't want to do that. Chi, with the remote exam, how is the MPT done? So my understanding is that essentially what they do is they give you two screens. They give you the whole file, which used to be a paper file. They give it to you, and that's on one side of. You can put that on one side of the screen, and then you have what you draft is in another window, if that makes sense. And I believe you get virtual scratch paper as well. Jane Dixon, how do you suggest to cite the rule? So again, for the essays, you don't need to cite. Unless you mean, there's no citation needed on the essays. Is it verbatim or you mean given the rule? Giving the rule, you want to be as close to verbatim as possible. You don't want to paraphrase because that can change the legal meaning of a rule. Now, being completely honest, I absolutely paraphrased some of the rules on the bar exam because I just couldn't remember them. But you want to make sure you minimize how much you're doing that. Let me stop sharing here. Here we go. Okay. All right, that's better. Now I can see the questions bigger because, as I said, law school took my vision. Okay, let's see. Let me see. Let me see. All right. Sometimes the rule itself is wordy and complicated. Yes, Jane, you're right. They are. So what I would say is make sure you have at a very minimum the buzzwords of each rule, right? But yes, some of the words, some of the rules are just, very, very wordy and just not any fun. How do you cite a jurisprudence as a rule? I don't know what you mean by jurisprudence. You mean, you can just say under the Constitution, under the rules of federal civil procedure, under the rules of evidence. Okay, let's see. Let's see. Merv, I was just curious if grammar mistakes will cost us losing points. On the essays, my understanding is it doesn't. On the performance test, I think excessive misspelling they could take points off for. Yeah, they can understand, but yeah. So okay. Okay, thank you for Kioma. Okay, if one does not get all the points in the point sheet on the performance test, can one still pass the performance test? Yes. If you think about it, the bar exam is graded out of 400 points, right? The uniform bar exam. And I mean, I scored a 303, right? Which is what, 76% of the points is the raw score. And my score was in the upper 90th percent, or in the 90th percentile plus of the country. So that goes to show you that the majority of passing people only get around 2/3, depending on the jurisdiction. They require a different score, but generally it's around 2/3 of everything is what you need. So yes, you can lose points, but again, they're easy points to pick up. So don't go in there thinking, I'm going to give up the points here. You don't need all of them, but you want to still do well on it. Because again, it sets you ahead. It gives you wiggle room on the essays, or it requires you to do perfectly on the essays. Let's see. Okay, Chi, on IRAC, you mentioned identify the issue and legal principle. What do you consider the legal principle? That's kind of the same thing as the issue, right? Which is what is the problem? That's what I was speaking to. Maybe it was a bit vague, but yeah, that's what I meant. So the issue, same thing as the issue. Jasenia, we need to buy all the laws to study first, or only with the BarMax is enough for a foreign lawyer? Jasenia, what I can tell you is that the BarMax materials, the book, the outline, which is also available electronically, all of that is enough to get you to pass the bar exam. So I hope that answers your question. Which again, that's going to have the rules and the laws that are tested, right? Juan Jose, in your experience in students, how many months do you suggest studying? I studied 10 weeks. No. The bar exam, no, I studied late June, July. No, I studied 8 weeks. I studied 8 weeks, but I think as a foreign student, you want to make sure you give it more time. Let me see. Yeah, so, again, it's up to you, right? It's like you start engaging with the material, you realize it's kind of dense, then you need more time, right? Okay, David, thank you. Sorry, Matthias, it's okay. Leighton decided to pop in. Any advice on how to more efficiently have a study group run? I'm part of a group. I was educated in the US, but live in a US territory. BarMax is the best, hands down. I'll take July bar and waiting on February results. I've leaned towards tutoring, but don't want it to be expensive babysitting. Is your memory photographic? All right, so a few things. How to efficiently run a study group? David, I'm going to tell you right now, I don't study with other people. I don't study with other people. I don't write motions with other people. I don't know, but that's just my style. I know that people, do well when they study with other people. So, but I'm the wrong guy to ask on that. I think when it comes to studying, I have a style, and so I do it on my own. Obviously, I teach my style because it works on the bar. You said you don't want it to be expensive babysitting. Well, David, here's what I can tell you. The degrees you see behind me are not babysitting degrees. So I don't babysit, I'm speaking for all the other tutors. They don't babysit anyone at all. What we're there to do is to give you the tools to make sure that you're ready to go. So we're certainly happy that you're happy with us. Sounds like you live in a beautiful place as well. Good for you. I've been freezing in New York for 4 months. Yeah, so if you go with the tutoring, it's not expensive babysitting. There's very few categorical truths in life, and that is one of them, that you're not going to get babysat. Is my memory photographic? I've had people tell me that. I don't even know what that means. To be honest with you, I do learn better by seeing things than listening. Yes. So that's maybe why doing a lot of things where I was writing out helped. Jasenia, thank you. No, thank you. Chi, I want to take the bar this July. Can I start studying now? I graduated 10 years ago from the UK. Chi, I don't know if I'm saying your name correctly, Chi or Ki. Yeah, you can start studying anytime, right? And if you feel like you're a bit removed from the materials, I think starting earlier is a better decision. So yes, you can study anytime. You can start anytime. If you're, my understanding is if you purchase our course, once you purchase it, it's available to you. So, anonymous attendee, do you have any thoughts on photo reading? I'm sorry, I don't know what photo reading is. Yeah. Javier Lopez, just a comment. I took 20. Oh, Javi, how are you? I don't know if you're still connected. I know that you sent that. Oh yeah, you just sent that. Well, thank you. Javi and I worked together for this last cycle, and I'm very confident that he just passed the bar exam. He's also a foreign student, and we had a lot of the conversations that we had today. We had with Javi as well, where we were. Yeah,
Matias, you didn't read his comment.
What's that?
You didn't read his comment out loud.
Oh, I didn't?
No, let everyone hear it.
Oh, well, it disappeared on me. It said, I think he said something to the extent of, it's worth every penny. He said, I took 20 hours with Matias and worth every penny, something to that extent. It disappeared on me. So
that is exactly what he said. Thank you, Matias.
Yeah, okay, no problem. Yes, Javi is, I look forward to getting in legal trouble in Texas one day, so that I can call Javi. He did some amazing work, but a lot of the conversations that we had in his tutoring, and some of them were in Spanish, were about, you know, the constitutional system in the US and criminal procedure and how it's so unique. And he also found torts to be a bit different than in his home country. And we just had to, I remember in one of the lessons, I just said, listen, Javi, this is the way the gringos do it, and let's just go with it so you can pass the bar exam. So, but once we had those conversations, it kind of opened up the floodgate. I don't want to speak for him, but I remember him telling me some of that. Chi, since I'm taking the bar this July, do you think reading from now is enough time? Okay, so I don't know if you had asked yes, okay, you asked a similar question there, Chi. Yeah, so you can start studying anytime. Therese Gutierrez. Hi, I'm a lawyer from the Philippines. Beautiful country, never been, but it's on my list. And I really want to take the bar. Is it hard to get eligibility? Are the qualifications the same in all states? Therese, I'm sorry, I can't, I don't know. I don't know the qualifications needed to take in each of the states as a foreign attorney. But I would encourage you to look at the state bar website for UBE states to see what it is that they require. I think that that's the best place where you can find that information. Janet Dang, what do you cover in tutoring session, i.e. how is the time utilized? So the way that I individually do these is we sit down our first lesson and we figure out what's what, right? If you already know some things that you've struggled with, if this is not your first time taking the bar exam, then we put those at the forefront. If this is your first time taking the bar exam, then we start working on process, I would say, first, meaning the first, I guess the second lesson. First lesson is laying out a game plan. Okay, how many hours do you have to study a week? What are your other commitments? You're going to find me telling you a lot of times, oh, you used to do this? Well, guess what? You're not doing it the next 10 weeks, right? Unless like it's a dire need. I took the bar exam as a single parent. I have joint custody of my daughter, and it was incredibly difficult, but it literally was the bar exam and my daughter. The bar exam and my daughter. Those are the only two things. I stopped working out. The only thing I was doing is eating, sleeping, studying, and spending time with Maya. So that's the first thing that we talk about. We build a calendar together. Then in the next sessions, Usually what I dive into immediately is how to write the essays. And I hit on it very, very surface level about what is required in the essays. But in my lessons, we just go deeper into it, and I have a method. If any of you wind up taking lessons with me, you will get sick and tired of hearing me say law because fact, because that to me is the golden key to unlocking the essay portion of the bar exam. So that's what I do. And then it's always a moving target, right? So if 3-4 lessons into it, maybe not that early, because 3-4 lessons into it, we're still working on developing a good writing style, which will also help in analyzing MBEs. But after I've worked with students over the span of 3-4 months, and you know, by the 3rd month, we're doing things really tailored to, okay, what went wrong, right? You took a test this week, this went wrong. Okay, this is the 3rd time it's gone wrong and it's commonly tested. So let's work on it, right? Are you struggling with multiple choice questions? Okay, so then here's what we're gonna do. What is going wrong? What I always tell my students is we can't move forward and act like nothing happened when there's a car wreck back there, right? Building a passing bar exam score is like building a house. If it's not built on a good foundation, it's gonna fall on your head. So, and the falling on the head is the, you know, the not passing. So a lot of times it's readjusting. It's moving the dial as new issues come up. Sometimes it's also, you know, being here to say, listen, the process is fine. You're not supposed to be scoring at passing 6 weeks out, which is something that all of my students struggled with last cycle, and I'm confident that they all did fine. If now until July is enough time, should I take the July? Okay. Chi, all right. So Chi, I see that you posted a few questions on time. What I can tell you is start now, see how you're feeling. You know, it depends on your time commitments. If you're available full time now, then you're probably going to be fine, even if you're 10 years out of law school. Do I think that someone needs to prepare for the bar exam for 11 months? No. Especially, you said you went to law school in the UK. That's common law. Presumably, yeah, you had to do the law school in English, so maybe not as big of a language barrier, although British people love adding U's to a lot of their words, but that's not really detrimental. Yeah, I think if you start studying now, you could take it in July, depending on how much time you can allocate a week to it. It seems like a lot to study. Any ideas on how to effectively study? It is a lot to study. How to study effectively? You know, there's no silver bullet. There really isn't. The best way I can describe it is treat it like a job. You clock in at 9 a.m. if that's what, you know, if you don't have any other commitments. You clock out at 6-7 p.m. at night. Treat it like a job. You're not there to mess around. You're not there to text your friends, post on Instagram, right? Just focus. And if you have other commitments, then you need to carve out time that is only bar study time and stick to that. I think if you do that, you'd be fine. Thank you, Bianca Ruiz. Okay. So Matias, do they have required format and essay answers? So they want IRAC, like I discussed earlier in the webinar. Do they prefer long and extensive answers, short, brief, concise answers? So Therese, we discussed this, but the UBE tends to prefer concise answers. Margaret, okay, even though I am not foreign educated lawyer, English is not my first language, I just want to mention here to those debating whether to take any tutoring sessions that time spent in my tutoring sessions with Matias. Oh, Margaret from Poland. Okay, she says, time spent my tutoring sessions with Matias. I don't like reading these things about myself, guys, but I will, since Celeste.
Okay, it says that Matias is awesome.
Yeah. Yeah, it just, yeah, Margaret is arguably one of the most intelligent people I've ever met. It was just getting her to understand she had 30 minutes to say what she had to say. That was the main, our main point of friction in our mentor-mentee relationship. Yeah, and by the way, I'm not someone who likes being tutored. Yeah, because you're extremely intelligent. I could see why not. But we're very hopeful that Margaret did well also. Actually, I'm very confident she did. If she stuck to the timing, she was fine. Trust me. Margaret, again, extremely intelligent. Medina, does BarMax predict like some bar reviews do? I don't think we're in the business of predicting. I don't know. Celeste, do we usually predict anything? I don't think we do we?
No, for the very reason that you gave, the story that you told about how your own bar exam, you decided not to prepare wills, and then you opened to the very first essay, and holy, it's wills.
Somebody,
you know? And that can happen to anyone. Plus, here's another fact. The subjects that people like to skip, those essay-only subjects, there's like about 4 or 5 issues to learn in each of them, right? So, like, if you get that essay, there are those handful of issues that are tested over and over again. You want to learn those issues. You want to be ready on them. So no predictions.
All right. So Medina, unfortunately, I hope, number one, I'm pronouncing your name correctly. And number two, we don't predict. So, okay. Juan Jose, how do we contact tutors? Okay. So, I know we get email.
Jose, just send me your email or phone number in chat, and we'll hook you up. We'll hook you up with some tutoring.
Yeah, Juan Jose. Yes, what Celeste said. Yeah, I think they give the list, and again, everyone is great that tutors with us. I don't think you can go wrong with any of us. I think just sometimes styles work better for other people, but that's on you all to choose, and we're all here for you regardless. Okay. All right. So no. That's not Q&A. That's just the chat. Okay. What is the most benefit of BarMax on preparing essays? So, I mean, the course teaches you how to go through them. I'm not sure if you're asking about the course or the tutoring. The course has other webinars and under office hours, which speak to how to tackle essays, which again, your knowledge of the law is only as good as what you put on the paper and get points for within the amount of time. Yeah, and then as far as tutoring, well, we work specifically on what you're doing wrong. So, and what I do personally is I give a standardized way to approach every essay. It doesn't matter if they're asking you about contracts, torts, conflict of laws, or God forbid, wills, right? We approach them all the same way. So we standardize that, which kind of cuts out some of the the uncertainty of the essay portion, which again, for me, was the portion that I thought I wasn't going to do as well on. Okay, so I did say your name right, Medina. Okay, great. By the way, I'm so happy and thankful for my students that popped in, both Javi and Margaret. I'm positive that both of them did amazing on the bar. They worked extremely hard. Do you have any suggestions about issue spotting? The thing that will help you with issue spotting is doing the essays, right? Do the essays, do them over again. After it's been a month since you've done that essay, go back and do it again, right? Get used to seeing factual scenarios that trigger certain rules. That's what I would say. Juan Jose, okay, no, thank you. How far back should we review the past bar exams? Is 5 years back enough? You know, listen, when I give my students questions, I give them questions. Sometimes there's a question I love testing from 2008 because I think it's a great question. So I don't know that. I mean, if you get BarMax, BarMax gives you like everything. So is there a way to approach it? Not in my opinion. Do you recommend reading then, Medina, do you recommend reading, then trying to practice questions, or trying out questions and read along? I say it's a mixed bag. I'd say early on you want to read and to make sure that you're, reflecting on the law, understanding what the law is, getting to know the law, and then doing practice. But that doesn't mean, do 80% practicing and then I'm sorry, 80% reading and only 20% practicing. You'll see as the time goes on in the studying, it's less just reading and more practicing and memorizing. So Medina, I'm also interested in tutoring because I'm a repeat. Okay. When is the best but when it's best to adopt tutoring? Medina, in my opinion, tutoring builds the foundation on the house, right? Because I've had students that came to me 3 weeks before the bar exam. Sure, we can dial in some things and work and certainly improve, absolutely. But at that point, you're trying to fix things, right? You're trying to fix the things that are wrong with the house. Versus early on, you're building yourself a good house, right? Which kind of gives you another thing for any of you that will wind up working together. Another thing you're going to get sick and tired of hearing me say is I am giving you the tools, right? You are building the house. I'm giving you the tools, and the tools are how to tackle each part of the bar exam the correct way, right? So how close to the exam? I think the earlier the better. So that way, when you go off and practice on your own, you're doing it the right way. Is there, okay, Medina, I hope that answers your question. Anonymous attendee, is there a textbook by BarMax I can purchase? Yes, we have the outline book, and we have an OPE book, which gives you 4 full-length, 400 question multiple choice tests.
Those are part of the course.
Right,
they
which is
are not sold separately because those outlines are really the heart of the BarMax course. We're very, very proud of the streamlined outlines that accurately teach just what is tested on the exam. So we do not sell those separate from the course itself.
Thank you, Celeste. Yeah, so like I said, folks, what I do is tutoring, so I don't even know the basics of what we what we sell. But I can tell you, I've probably spent more time with that book than I did with the Bible growing up as a Catholic. So I can speak to how good it is. Okay, Grace, Miranda rights and Fifth Amendment rights, are they the same thing? So we discussed this earlier. Oh, this is from 4 p.m. Okay, so this, oh well, I guess at another time zone, whatever. So the Fifth Amendment, just briefly, we can't go into too much detail about it just for time, we're almost running out. The Fifth Amendment of the US Constitution protects the right against self-incrimination. Originally, that meant that you could not testify against yourself in a criminal proceeding, right? I couldn't be forced in a trial to take the witness stand and say, yes, I did steal that. I'm trying to think of something that is not egregious. Steal that book, right? 200 years later, and after the fiasco that the post-Kennedy murder was, Justice Earl Warren decided that we needed to extend that constitutional protection that the Fifth Amendment affords to encounters between citizens and the police and when I say citizens, I mean anyone within the jurisdiction of the United States, irrespective of immigration status or lack thereof. It extends to any time that a suspect is in custody by the police, as defined in Miranda, and being interrogated by the police. So they have a Miranda right against self-incrimination, a right to remain silent. So for any of you who have ever seen an American movie, we like to fetishize police encounters, and everybody's always getting read their Miranda rights, and you get these things about you have a right to remain silent. Anything you say can and will be used against you in a court of law. If an attorney, if you cannot afford an attorney, one will be provided for you. Which, by the way, cops never do in real life, tell you those things. But that is an extension of your Fifth Amendment rights, which came from the case Miranda versus Arizona. So I hope that answers your question. I think I answered all of them, didn't I? I don't know. Celeste, did I miss any? I see things in the chat, but it doesn't look like the chat looks like it's just more exchange of information. Oh, I see Margaret.
Yeah, a lot of people are sending us their contact information, and hang on, let me turn my camera back on since.
Well, I'd love to read all these comments later, but they look like they're extensive. I didn't get a chance to look at them.
I'm sorry, now I'm having trouble with Zoom. Anyway,
I hope I answered. I mean, folks, we got another 5 or so. So if somebody wants to throw in.
Yeah, no, we do need to cut this out because we need this. We have another webinar coming up. Oh. So yeah, so we got to get going. In fact, we have to cut it right off. I just realized that. So here I am. Okay. And if we fail to reach out to you, I think we've got all of the phone numbers and email addresses that you've sent to us in chat and Q&A. But if we fail to reach out to you by tomorrow or even today, if you want to reach us, you can find us. Just, click the links at BarMax or go to getbarmax.com and you'll have all the links there to reach out to us so that we can hook you up with the BarMax tutoring or the program or tutoring that'll get you, past the bar and being a practicing U.S. lawyer. Matthias, you've done a tremendous job. Thank you so much.
Thank you. Thank you. I hope this was useful to everyone. Look forward to working with all of you and forward to suing your clients in the future. I'm sure. As long as everyone is doing well and doing good, then we have fulfilled our purpose at BarMax, right?
All right. Thank you all.
All right. Take care. Bye-bye.